Good afternoon, everyone, and welcome to our shifting even the title webinar program, Pandemic Planning. We're now calling it Managing the Unprecedented. Thank you for joining us. I know this is a tough time and quite hectic for most of you. So finding a way to take an hour and a half out of your day to hear us, we're honored to have you here. For those of you who are unfamiliar with our firm, Stringer LLP is a management side labor and employment law firm. We represent employers across Canada and have done so for more than 50 years. And we're committed to helping you and our valued clients weather this storm and come out the other end when the recovery finally emerges. The opening I had planned has now changed, and the result is because of an announcement by Prime Minister Justin Trudeau that just happened this morning, not 45 minutes ago, where he announced a number of additional measures that the government is implementing. We don't have full details on them, but I thought I would share what I've gotten from the broadcast. First of all, the overnight rate has been cut to 0.25%, Bank of Canada. Second, they have taken the wage subsidy, which you may understand this isn't sort of strictly speaking HR law, but the wage subsidy, which was announced for small incorporated businesses of 10%, which was the ability to, starting on the 18th of March, to deduct 10% off of the remittances to the federal government until you hit a maximum of a certain amount per employee and 25%, $25,000 per organization. That has now been increased retroactively to March the 15th to 75% of remittances, and more information is coming. We don't have all the details yet, but that's quite substantial. We're also hearing that the Canadian the employee benefit, which is available for people who don't qualify for EI, is still being maintained and may be enhanced. More details to follow. And they've announced for small businesses which qualify $40,000 loans, interest-free for 1 year, and for the smaller of and more fragile businesses, I suppose, where 10,000 of that will be simply forgivable. And finally, they've announced that businesses can defer their HST and GST payments until June, interest-free. Of course, that begs the question: what happens when June comes knocking? I think one would expect we will hear some additional announcements, because the PM was encouraging folks to spend that money. And I don't see how you can spend that money and then cut a check June 1st. So we'll wait and see. Again, this was just announced half an hour ago, so our slides have not been updated to include any of this information, some of which is more business than HR, but I just wanted to cover that for those of you on the call. Certainly, these are unprecedented times. When we initially announced this webinar was coming, we were looking overseas and seeing what was happening over there, but it hadn't really hit us to the same extent. And within not even a week of our announcing this webinar, the world, it seems, turned pear-shaped and upside down. And so we've added some things to this webinar, if you've seen our site, and we also have a number of other issues that we're going to cover. Finally, for those who may not have seen it, we've increased the length of the webinar by 30 minutes to account for the questions that we expect we're going to get. I will also say that if you are unfamiliar with the GoToWebinar platform, on the right-hand side, there's a little box where you can put your questions in and send them. Because of the structure of this and just how much material we have to cover, we're going to hold questions to the end. But if you do send your question in at any point, we'll put it in the queue and we'll do our best to answer it. If you don't see the box, then hit the plus sign to expand the window in order to type your question in and send it. And if you don't even see that, then hit the orange arrow, which will open up the control panel and allow you to expand the window to send us your question. So without any further ado, let's get into some of the sort of meat and potatoes of what we're talking about here. We need to talk about the employer's obligations from a health and safety perspective. And Ryan's going to go into that in a lot more detail later on. But very importantly, employers have an obligation to keep their employees safe, to comply with the government directions that come out from time to time, including from public health. But also, you're going to have certain employment law obligations that may not necessarily overlap cleanly. And we're going to go through some of these areas. So, for example, when we're talking about issues of employment standards, health and safety, human rights, employment insurance, a lot of these statutes, they were drafted ostensibly as a large patchwork of legislation that's supposed to work together. But in many ways, I think, especially when it comes to the difference between federal legislation, sort of the tax and employment insurance aspect, and provincial legislation, they don't always fit together like cogs in a machine. And we'll talk about a few of those issues. Attendance management and flexible work arrangements. Obviously, these are issues that we're going to be discussing both from the work share and more formalized systems, but also from a more informal perspective. What happens when an employee is requesting one of these flexible arrangements? Can we put those in place? What's the impact on other things we want to do, such as work sharing? Implementing pandemic preparedness, prevention, and response plans. So this is a bullet that quite clearly was prepared before the world turned upside down. So many of you are, if you're without a plan at this point, you didn't have time to create your business continuity plan, then you're going to be putting one together on the fly, piece by piece. And so that's unfortunately where a lot of you are. Hopefully you get some insight through this webinar, and we're able to assist you further there. So let's talk about some of the attendance management and flexible working arrangement issues. So first of all, staffing issues. So there will be employees who are off work as a result of self-isolation or quarantine, or who are off because of other types of leave. For example, if the government has initiated a declared emergency leave, as it has in Ontario, and has determined that your business, not specifically your business, but your type of business, is not an essential service, so you're not exempt. And so you may need people to be working from home. You may need to put in place infrastructure to do so securely, and you may not have employees who are able to do that, either because they don't have the structural support, they don't have internet, or they don't have laptops or other equipment necessary, and good luck finding those on the market today, or simply because the kind of work they do doesn't fit within what you could do remotely. You're going to need to look at your absenteeism and your attendance policies. So some of the issues here will be that when you drafted your attendance management policies, your absenteeism policies, you didn't have a pandemic in mind. So when you were thinking about how many days you could have somebody off with pay, that was, I assume, calculated based on the presumption that you wouldn't have 50% of your workforce off on an isolation or quarantine. That is something that unfortunately a lot of employers are either facing or contemplating at this time. And so you need to give some thought to whether those attendance policies and absenteeism policies from a financial standpoint are sustainable. And you need to give some thought to whether you can make changes to those policies without that constituting a constructive dismissal. And we'll talk a little bit about that later on. From an attendance management perspective, of course, the government has indicated that it does not want employees flooding into doctors' offices seeking medical notes. So although the typical response of HR before, of course, was for employees who had a history of absenteeism issues or who were off for a significant period of time, 3 days or more, get us a doctor's note. And if you want to return to work, you need to get us an all clear from your doctor. Those rules need to be reassessed in these circumstances. And I think all employers need to have a hard look at that policy and decide whether they need to include new provisions, both to deal with the practical realities of our situation, but also to ensure that they're not requiring medical notes in circumstances where they're no longer permitted to ask for them. You may recall that when Mr. Ford became our premier, one of his first acts was to unwind the prior changes to the ESA, where Ms. Wynn's government had changed the law so that employers in certain circumstances could not require an employee when submitting evidence reasonable in the circumstances to provide a medical note. And so Mr. Ford's government removed that and returned to employers the right to request a medical note. And of course, now with the COVID-19 declared emergency, they've now removed that for COVID-19 related absences. And so you need to have a look at your policies and make sure that either you change them or you simply don't implement or enforce the provisions that are no longer lawful. We're going to be dealing, of course, with scheduling issues, especially if we have work share arrangements or otherwise, and we need to be very flexible about that. You need to also remember, again, and we'll talk later about making changes to your workplace in terms and conditions for employees, but you need to keep in mind that the changes you make may have an impact there in terms of constructive dismissal and things like that. Finally, of course, meetings, workplace events, social gatherings, at this point, those are all canceled and going to Zoom or in our case, GoToMeeting. But you need to give some thought to what impact that'll have on your operations. Now, this is very important, and we've been seeing a lot of articles out there and people, employee side counsel going on the news talking about how any changes, any temporary layoff may be a constructive dismissal if you don't have the right to lay off. And the law on this is actually not very nuanced at all. In general, if you don't have an express or implied right to lay somebody off on a temporary basis, even if that's implemented in accordance with the rules and limits of the Employment Standards Act, that does not grant you the contractual right to implement a layoff that you didn't either expressly or implicitly have the right to implement. And so the impact of this is an employee who is given a temporary layoff for whom you do not have the right to institute a temporary layoff now has a choice. Are they going to wait and see whether the temporary layoff becomes permanent, in which case they've been terminated, or do they want to wait and see and accept a recall either to mitigate their damages but still claim that they were constructively dismissed, in which case they'll get their employment standards entitlements on a claim and potentially common law damages, at least to cover the amounts over what was mitigated? Or are they just going to tell you, no, you cannot lay me off at all, even on the first day? That's a constructive dismissal. And in our experience, at least from the last financial crisis, most employees did not take that tack. They waited to see, and then they phoned their employment lawyer when the dust was settled. It's going to take a long time for the dust to settle here. And so we're recommending, and we'll go through this later, strategies where you believe you have a risk that implementing a temporary layoff will lead to a constructive dismissal that will help you to avoid that risk. So also keep in mind that a constructive dismissal isn't just a temporary layoff where you don't have the right to do it. It's also implementing a workplace change unilaterally that has a fundamental impact on the core of that contract, the terms and conditions. And of course, from a financial standpoint, the rule of thumb, although it is by no means an across-the-board rule, is if you're implementing a change that results in a 10% reduction or more, it's almost certainly going to be a constructive dismissal in terms of take-home pay. If you implement a unilateral change that's less than 10%, then typically it will become a question more of fact. What are the individual circumstances of that employee? Again, employees may be required in these unprecedented times to keep working even though they don't accept it. And if they condone these changes to their working hours or compensation, directly or indirectly, for a period of what the courts would call reasonable, and there is no bright line test for what is reasonable, they may be deemed to have condoned that change. So many employees will forget that they have to tell you that they're going to work it, but that they don't agree to it. They'll just come and agree implicitly by working. And if that situation goes long enough, that will be their new terms and conditions, that you're allowed to unilaterally on a temporary basis implement these changes, and it won't be a constructive dismissal. That won't stop them from filing a claim, but it may give you a defense. So that's also very important. But the key to both of these issues, layoff and changes to hours of work and other restrictions, is unilateral change by the employer is required for it to be a constructive dismissal. So any opportunity that you have to get agreement for these changes will be your 100% full salvation, right? As long as you have an enforceable agreement and they have agreed to that change, preferably in writing, then you have a defense. if they were to later say it was a constructive dismissal, because it's not if they agreed. I believe, Ryan, this is on you now.
Hey, Jeremy, I'm actually not able to see the screen. Is there any way we could work on that situation?
Oh, has that been the case for a while? You can't see it?
Yes,
I think that perhaps nobody has been able to see it. I'm very sorry, everyone on the call. We'll I believe you should be able to see it now. Is that the case?
What I see is a blank screen.
All right. So again, my apologies to everybody. After this program, we will be sending out the slides. Thankfully, the stuff that I was talking about right now, I pretty well spoke to every bullet that would have been on your screen. Again, my apologies. I'm now going to hand my mouse over to Ryan and my keyboard so that he can avoid me having another technical glitch. So Ryan, the conch is yours.
It is, Jeremy, but I still don't see the screen, man. It's blank.
You still don't see the screen?
Blank.
Okay, bear with me. I'm looking at the audience view, which according to my panel says that everybody can see my screen with the slides.
Okay, that is not the case for me, so it isn't. So what I'm going to suggest you do is, why don't you just run through the slides and I will insert commentary as required. Oh, no, got it.
Okay. You got it now? Okay, I don't know. I have no idea what I did, but here you go, Ryan. It's all yours.
Sorry about that. I guess we're probably familiar with all these technical difficulties during this sort of transition to working from multiple locations. All right. So look, obviously, an employer's duty is that my background in health and safety law, so I'm happy to take you through perhaps a time when health and safety law is more important, frankly, than it's ever been. Employees have a duty to attend work fit for duty, which means, sober and all those other things, and to work in compliance with health and safety legislation and work in a safe manner. These are all the generic duties that come under the Occupational Health and Safety Act in Ontario and frankly elsewhere. If we get to the next slide, Jeremy.
Oh, are you not able to click the button? You should be. On your keyboard? No? Okay, I'll do it.
No. All right. So the Occupational Health and Safety Act, obviously has a general duty clause in it, which applies obviously to pandemics to take reasonable precautions to prevent harm to workers. What is reasonable is things I think most reasonable is following generally recommended precautions, which such sources as the federal government, Health Canada, the medical officers for both the province and various municipalities have all been advising the same sort of thing, distributing antiviral products and contracting for additional cleaning services to the extent that's possible in these times. Obviously, one that we're all doing, I'm sure that where we're able to, is to allow employees to work from home. Sending symptomatic employees home, having a direct policy that symptomatic employees don't come to work, obviously restricting work-related travel, and obviously other such that it may be in some cases that the inherent nature of the operation, for example, social distancing and others, is impossible to operate, so you may just have to close your operation entirely. If that's the case. Next slide. So basically, in what circumstances can an employer say that, you go back to slide, please, can an employer say that the employee is required to remain off work? Well, obviously, someone who's either diagnosed or symptomatic of COVID-19, where an employee has recently traveled to a high-risk area. And I think that is not just confined to what the federal government has spoken to, where people that have, even if you went to Niagara Falls, New York for 5 minutes, you're supposed to be quarantined for 2 weeks. People that may have been to Vancouver or other places within Canada where there's a significant spread of COVID-19, it may be probably quite useful to sit there and say you have a legitimate basis to keep those people home. Obviously, where an employee has declared they've come into close contact with an individual that's been diagnosed with COVID-19, or even one could even say showing symptoms, remembering that testing for COVID-19 is still very limited in Canada and elsewhere due to just the limited number of tests and the prioritizing who gets those tests. And obviously also those who are just shutting down, those that are required to close by government order. Next slide. The province of Ontario has issued a list of essential services, and it's probably not a time to be cynical, but certainly the list of essential services is probably broader in this province than it is in other jurisdictions across North America. Laundromats and check cashing services, amongst other things, have been considered essential. But widely, really, so there wasn't a dramatic change, quite frankly, from when the essential services list came out, that by that time already restaurants, bars, arenas, theaters, and other things where people gathered close proximity had already been closed by government fiat. So ultimately there isn't a dramatic change, but the big change is that there is serious and significant penalties that if you're an essential business that's operating, you're caught being operating, you can be hauled into provincial offences court and pay significant fines. So for those of you who think it's close to the line, you're going to want to get some legal guidance or err on the side of caution, because there's no doubt the Premier himself has been calling out people by name that have offended him for legal reasons and otherwise, be it the $30 Lysol, etc. Lastly, one important thing is the Occupational Health and Safety Act has always had a list of groups of people that are exempt from the work refusal provisions. These are primarily, but not exclusively, in the law enforcement and medical field, with exemptions for services that supply those entities in certain circumstances. Basically, those entities are not allowed to refuse work where the task is either inherent in their job, or the risk is inherent in their job, or that they would put the life of someone else in danger, which does limit the ability significantly of those sectors to engage in work refusals. And the Labour Board has made it clear that in those circumstances, workers who refuse to work are subjecting themselves to discipline, possibly even termination in these circumstances. But the one thing that has to be clear is that the OHSA exemption does not line up with the province's list of essential businesses. So if you are outside that sort of law enforcement medical realm, the work refusal right still exists, and it's certainly one that has come up extensively in the construction industry. I've dealt with a number of instances of this over the last couple of days, where employers are saying that the province has declared most construction to be essential, but much construction work is, of course, not subject to it is difficult to operate within the social distancing requirements of 2 meters, where people are not interacting. So certainly, I've seen a variety of interpretations as to how that should operate, from what only those entities that can permit social distancing should continue to operate. Has sort of been the more conservative advice, but certainly there has been no definitive guidance. What I can tell you is in the guidance released by the province of British Columbia for construction site, it says to avoid social distancing where possible. So again, that issue will evolve over a couple of days, and those of you that are in those industries are probably going to need some more specific advice. But generally speaking, as of this morning, there isn't extensive materials on that. Next slide. Ultimately, so for those of you who are subject to work refusals, these steps are, as they've always been, an employer has to basically report the concern to their supervisor. The duty to investigate is triggered. I think for most of you, it's going to be pretty inherent. It's going to probably be a very narrow issue most of the time around social distancing if your industry is still operating. And then if the employee has reasonable grounds, then it then ultimately goes to the Ministry of Labour to decide. And my understanding is the Ministry of Labour has been flooded with these and is making telephone decisions as they can, not entirely consistently either, I might add. So it's certainly an interesting situation. Those of you who are in a work refusal position, again, may ultimately want some legal guidance in terms of how to navigate it, because obviously this is an incredibly legally and politically and quite frankly factually sensitive issue, particularly in light of the fact that there's a broad range of entities that are declared essential, and it's not at all clear to me that just because you're declared essential that means that some of, for example, you get some kind of exemption from social distancing. I think in fact quite potentially the opposite. Next slide. WSIB, just wanted to give people an update on that. The WSIB, much like other taxing authorities, has allowed the reporting of earnings and payments and premiums to be delayed until August 31, so you can delay your WSIB premium reporting and payment of premiums till then. Workers who are on modified duties, who are sent home as part of a COVID-19 shutdown, do not get LOE benefits. So that's it. Basically, this is consistent with the board's historic policy on these kind of issues. But workers who are on benefits at the time of the shutdown continue to receive benefits even if they were scheduled to come back prior to the shutdown. The statutory appeal limits for WSIB and WSIB, those of you who are appealing workers' comp, those are suspended as a part of the province's overall general order suspending limitation periods. It's important to appreciate, as Jeremy will get into, that some decision-making bodies, such as the Labour Relations Board, are still operating in some respects. But for WSIB, the time limits are currently suspended, and there's certainly some talk of some adjudication of hearings by writing, and then it'll be interesting. There's no formal announcements beyond some very general comments from the board that's about what's going to take place. Next slide. Obviously, for those of you who were curious about how workers' comp will act with COVID-19 itself, workers who contract COVID-19, as with any other occupational disease or a accident, will be entitled to work. Will be entitled to benefits. Entitlement will usually be granted when the nature of the worker's employment created a risk of contracting the disease to which the public is not normally exposed. You know, in the obvious sectors where this is going to be the case, things like healthcare, perhaps construction, where social distancing measures weren't in place, where there's been reported cases of it. And one must also remember, as always with workers' comp, that where the evidence is approximately equal in favor of entitlement and not, the entitlement is granted. A requirement that's sort of been buried and forgotten, which still is in effect, is that if you do have someone who has contracted COVID-19 at work, even if you did, quite frankly, even if you're going to ultimately dispute that finding at workers' comp, you need to report that to the Ministry of Labour within 4 days. There is an old, often obscure provision that even most of us who practiced extensively in this area don't think much about, but that obligation exists, and the Ministry of Labour does need to be notified by fax or other means in writing within 4 days if there is such a diagnosis. Next slide. All right, so going into employment standards, the province of Ontario has historically developed a long list of leaves that exist. First, the payment of wages in general, when someone is sick under the historic law, is that, absent a contractual entitlement, paid sick days, etc., are not a legal requirement. But ultimately that can vary depending upon the terms of your employment contract, depending on the terms of benefit plans, depending on the terms of the collective agreement. For those of you in unionized environments. Also, of course, employment insurance, which has been substantially modified in recent days, including a waiver of the notice of the waiting period for those that are actually in quarantine. Obviously, also, as Jeremy mentioned at the outset, there's also been a development of an employment insurance-like program for those that wouldn't meet the hours or such as a self-employed that don't meet the requirements to get a similar type payment to the maximum payment under employment insurance is not an incredibly significant amount, but it caps out in the $550 range. But basically, in terms of whether you what issues arise, Jeremy talked a little bit about constructive dismissal. Obviously, if someone's there's a leave that's imposed, whether it's by the government or the person's condition, you are in a situation where it's unlikely you're going to have an argument of constructive dismissal. However, and then also you need to consider that when you're trying to encourage employees to report symptoms, that the thought of them going home without pay does encourage people to mask their condition, sort of in the way some folks we heard about in the media were masking their condition to get on flights, unfortunately, which has worsened the conditions. So you've got to bear that in mind. But for those of you that are in situations where somebody has been, where you're simply laying people off because of COVID-19, whether it's by government order, I think a constructive dismissal is probably not impossible, but not likely to be successful. And otherwise, when you're dealing with a constructive dismissal as it relates to someone who's shut down, not because of government order, but just because of lack of business, I think you might find some creativity in the courts to avoid saying that someone is entitled to launch a constructive dismissal claim, or if so, that their claim is likely capped at the amount of time that they are actually off. We've certainly seen some articles in the media of late that have suggested that there'll be jackpots for employees that are, especially long service employees, that are laid off. I'm not sure that's part of some more wishful thinking on part of the plaintiff's bar, as opposed to what actually will happen when the courts return. Next slide. So these are the various leaves that are under the Employment Standards Act. Obviously, these, most of you are probably familiar with these. There are so many leaves under the Employment Standards Act in Ontario, it's hard to fathom what's not covered by one of them. But what I did, obviously, briefly, what is important, though, is the declared emergency leave, which lines up with the provincial declaration of emergency by the Lieutenant Governor and Council, which basically says people that are not working because the province has said you can't open, which is a huge swath of the provincial economy, have certain protections that prevent them from being reprised against, obviously, in that situation. And it's also going to be difficult, although, for me to imagine a situation where that situation would be declared an employment standard. Next slide. So ultimately, this is look that the new declared emergency leave came as part of the whole initial legislative package by the province dealing with this issue, and amongst other things, it has to be a public health emergency in Ontario, and in order by the Lieutenant Governor and Council, the Premier. Essentially, the Lieutenant Governor and Council is just a fancy legal way of saying the cabinet. It's express begging back to our British heritage. Obviously, SARS Emergency Leave and Recovery and Strategy Act remains in place. So those are my comments. I'm going to turn it back over to Jeremy.
All right, so let's talk about human rights, which it's sort of odd during these unprecedented times to be talking about this, but there's a few things we need to discuss. First of all, is contracting COVID-19 a disability within the meaning of the code? Well, if we look at prior pandemics, H1N1, SARS, if we look at what the Human Rights Tribunal has found historically when it comes to illnesses like the flu, sort of the standard flu that goes around every year, the answer is no. Okay? But as lawyers, we're forced to say no, but. And the unknown here is really because this is an unprecedented scale situation. So first, if somebody contracts COVID-19 and they suffer the more severe symptoms, as opposed to just being off for a couple of weeks and then they're back to normal and healthy and good to go, no worse for wear, I suppose, and counting their lucky stars, those folks are unlikely to be able to say that that is a human rights disability within the meaning of the definition in the code. Folks who have the more severe, though, may have an argument that what they have is a human rights illness. Of course, if somebody has an argument that they contracted COVID-19 in the workplace, a la WSIB, as per Ryan's comments before, of course, the code defines any workplace illness or injury as a disability within the meaning of the Human Rights Code. So you want to keep that in mind when you're thinking about this. If you do, I don't know if we'll be thinking about this in the days right now, but perhaps in the days to come. If someone says, I contracted COVID-19 in the workplace, and the Employment Standards Act says that they're supposed to go on quarantine, but you're not allowed to ask for a medical note because of the declared emergency, then the employee says, I'm initiating my workplace claim. Here's my Form 6. Send your Form 7, and but I can't go to the doctor for my Form 8. What do you do? Well, I think in those circumstances, you have to presume that this may be a workplace illness or injury until proven otherwise, and as a result, you have to treat it once the claim is in the works as a workplace disability within the meaning of the Human Rights Code. Keep in mind also that people with underlying conditions may be affected, of course, more than others as a result of the way COVID-19 affects the body. And so even if contracting COVID-19 itself isn't a disability within the meaning of the code, because it's not work-related and because ordinarily they would not be suffering severe symptoms, if they have an underlying case that's exacerbated by that exacerbates the impact, rather, of COVID-19, then this could become at least put together a disability within the meaning of the Human Rights Code. You want to keep an eye out for your requirements to accommodate. So if you are still working, if you're still operating, you're not subject to the essential services carve-outs, which mean that you have to shut down except for remote work and certain classes of people within your organization, then what are you doing when it comes to accommodation of employees, whether they're remote working or whether they're working in the in your facility, who either contract COVID-19 or have other disabilities while this is going on? Don't forget that the human rights obligation to accommodate all disabilities to the point of undue hardship still exists, and so. I think that that's a very important thing to keep in mind, is that the world, even though it's upside down, is still turning. So we want to avoid human rights complaints that may come down the road. So another thing that I think we need to talk about is travel restrictions and other things. So the travel restriction is much simpler now because, quite frankly, the government has told people to stop traveling. So that's relatively easy. But in terms of the forced self-quarantines, again, you're being told as employers that you're not allowed to ask people for medical notes. So if they tell you that they've been told by telehealth Ontario or by their doctor that they may have contracted COVID-19 based on their symptoms, you are required, even if you're operating, to either believe them or look for other reasonable evidence in the circumstances to support their leave and ask them to provide that. But I have to say, in all but the most exceptional cases, you should probably just be taking their word for it. An employee who's going off on a quarantine because of a medical direction is, of course, eligible for employment insurance under an ROE where you code it D for David, for illness or quarantine, and then their EI's problem. Also, an employee who's off on a leave, which is a disability leave, is not on a layoff. And so you don't have to worry about constructive dismissal. So unless that person is occupying a role that you just can't do without them, then my best advice in these circumstances is, for all the reasons discussed, just take them at their word and let them go off on a disability leave for the time that they say their doctor has told them to quarantine. Now, at the end there, we've got a bullet there about the Ontario Human Rights Commission policy statement. So I put that there because I have to. The Ontario Human Rights Commission, following the direct access model to the Human Rights Tribunal, which some of you may recall way back in the early 2000s, the government decided to let people make applications directly to the Human Rights Tribunal of Ontario, as they have done in other jurisdictions, and avoid having a commission that would inquire about the complaint first, investigate, and then make the determination of which ones to forward to the tribunal. So they did away with that. They now have the direct access model. And the commission, although it does have the power to initiate its own tribunal applications or to participate in ones that have already been filed, it more or less now occupies a role that's advisory to the public, putting together information about how to comply with the code and how to help employers and other organizations captured by the code and its obligations to comply. And I guess you have to take what they say on this point with a grain of salt. They seem to be saying, if you read the full statement, that there may be a perception of a perception that is more negatively acute when it comes to people in marginalized communities or of certain ethnic groups, such that if they have or they are perceived to have COVID-19 because of their association with that group, or the taint on their reputation or how others see and treat them is different because of COVID-19 and those other factors, that somehow that may not necessarily be a disability, but it may be a perception of disability, and it may lead to other grounds potentially under the code. So, for example, I actually heard stories of some employers when an Asian Canadian employee would cough, they would send them home because for fear that they had COVID-19. I mean, obviously, unless there's some other risk factors that would present for them as opposed to other folks, sending that person home as a knee-jerk reaction is probably just a discriminatory decision on the basis of their race, and in this case, a perception that they either have or could have COVID-19 related to those other factors. So I'm just listing that because there is that guidance from the commission, but again, that policy statement does not have the force of law, but we'll see to what extent that applies going forward in human rights and employment law cases with a human rights angle in the future. Now, I want to talk about a couple of programs that a lot of companies have been asking about, and I have to say, I suppose employers are lucky. One of my contacts sent me this really funny joke. So, Drew, if you're on the call, you'll like this. As a lawyer, I heard that snakes are not affected, so I guess lawyers are safe. So, for those of you who laugh at lawyers' jokes, there you go. But these we've actually been quite busy in these first few weeks of this serious aspect of the crisis, both taking the health and safety and workers' comp calls that Ryan has been fielding, but also dealing with serious concerns by employers about how do they implement workplace changes, how do they implement layoffs. They're hearing from the plaintiff side bar basically saying, we're lining up plaintiffs to sue you if you do this. And we might wait to see when the dust settles which companies are still standing and worth suing, but we're ready to do it. And what you're doing, I think, to one plaintiff side counsel, he's actually calling it illegal. So, I mean, it's a breach. If it's a breach of contract, that doesn't make it illegal, just for what it's worth. It's a breach of contract. That's a civil wrong, not a regulatory breach. But in any event, there are ways to avoid constructive dismissal. There are ways to support your employees during this crisis. And the government, to its credit, has been doing a few things, and I think they can probably do more and will do more to support employers who need to find ways to support employees. So again, going back to our slide, I guess you didn't see the slide, going back to our discussion on constructive dismissal. A constructive dismissal is defined as a unilateral act by the employer that strikes at the core of that employment contract in a negative way, of course, and then the employee has to say within a reasonable period of time, I accept that change, or they can accept it by condoning that change over a period of reasonable time, or they can say, I don't accept that change. And at that point, they have two obligations. One is to mitigate their losses, and two is to in theory, look for work somewhere else to mitigate. Obviously, looking to mitigate by looking for work is not really going to be on right now, not likely, but mitigating by working under the conditions may be something that employees have to do, whether that means accepting that a temporary layoff is happening, and if the employer can bring them back within the 13-week period provided by employment standards, coming back to work to at least minimize or cut off their losses, or two, to accept reductions in pay or hours, even though it's having a serious financial impact. Now, I'll tell you that a lot of our clients are saying, well, we don't want to cause a constructive dismissel, but if we reduce people's pay by something that would be less than the constructive dismissal level, even 20%, or even if we do a little bit more than that and we take a risk, we sort of roll the dice if we don't have the right to lay people off, and we do it, we just implement 2-day-a-week layoffs, and everybody comes in for 3 days, that may not be enough, and it isn't enough to trigger the obligation to issue an ROE, because they're not earning less than 60% of their typical weekly wage. And if you don't issue an ROE, they can't go looking for EI. And so in implementing those changes to minimize the impact on you, you're not actually providing them with access to the supports. And it's not entirely clear from the government's updates whether employees who are still employed and who, if they suffer a little bit more of a reduction in earnings, would qualify for EI, if they would qualify for these additional support benefits that were announced for people who are more likely independent contractors or people who don't have enough insurable hours because they're part-time employees. So it's entirely possible that you could implement a one-day-a-week shutdown for everybody. None of those employees can go apply for EI, and now as a result, everybody has to just eat that 20% reduction and keep working for you in order to avoid their loss, and then down the road, sue you for constructive dismissal. And when they do that, they would have a right to their, at a minimum, employment standards entitlements to notice and possibly severance pay, but also potentially to a common law claim for the reduction to that point and possibly going forward, depending on how it goes. So keep that in mind. But the programs that we have here, this first one is actually quite useful, and I've had some early success getting employers on these plans. They're relatively straightforward. This is called a supplemental unemployment benefit plan. This is a plan that you create. There's a template on the government's Service Canada website with some information on how to create it. It can be a bit complicated, even though the bullets look a little bit straightforward. It's important to get it right and not to tailor the plan in a way that would make it non-compliant, because then it will get rejected by Service Canada. And it's also important not to miss an opportunity to tailor it in a way that helps you, in this case, to avoid constructive dismissal risk. So if you've got employees who you're allowed to temporarily lay off and you want to do this anyways, then there's no need to have the schedule that I'm going to suggest. But for our clients who are looking at sub-plans as a way of hedging against or avoiding constructive dismissal risk, again, if you can get employees to agree to a temporary layoff or to a sub-plan in this case, then they cannot sue for constructive dismissal successfully because they've agreed to it. So briefly, a sub-plan, as it's called in short, is a top-up over EI, which is for anything from 1% to a maximum of a combined 95% when you add EI that they're getting and the sub-plan payment that you're providing on a weekly basis. They don't, and this is the key, once registered, payments under the plan are not considered EI insurable earnings. And as a result, they don't affect an employee's entitlement under EI. In fact, you calculate their entitlement under a sub-plan by getting them to verify that they're on EI and telling you when it's going to start and how much they're going to get by downloading the printout from their account online from Service Canada. They provide that to you as verification, and you use that to determine what they get under your plan. These plans can be from 1 week to indefinite, although a requirement of the plan is that payments only be made while someone is in receipt of EI. And so you can't, generally the plan will only apply to employees who are still employed. So if you have an employee who at 13 weeks is no longer your employee, you're not going to be paying them under the plan anymore because they're not employed. You're going to terminate their employment. However, if you have employees who are unionized and so subject to recall rights under the collective agreement, it's permissible to have recall rights expire at 35 weeks in a 52-week period of layoff. So you may have employees on a sub-plan for up to 35 weeks. So make sure you give some thought to whether you have unionized folks, of course, involve your union as well if you decide to put in one of these plans. You can determine eligibility of employee by category in your plan. So you might have a separate plan and different top-up for salaried folks than for hourly folks. You might have managerial and higher people getting one thing and hourly folks getting another. It's entirely at your discretion, as long as you follow the rules of the employment insurance program under the Employment Insurance Act. And of course, the length of the plan is either the plan itself can be in place for a minimum of a year, a maximum of 5 years, but you determine how many weeks the benefits will pay out. So again, it could be 1 week, it could be 13, it could be indefinite, up to you. Now, again, just to go back to that briefly, the plans that I'm helping employers put in place, although this isn't available on the website, I have a schedule that we've created as a firm that we attach to it, where basically employees, in order to be eligible, have to sign on a document which says, in consideration for the employer implementing this supplemental unemployment benefit plan, I agree that the employer can implement a temporary layoff within the constraints and subject to the limits of the Employment Standards Act in my jurisdiction, without that being a constructive dismissal. And so once that employee signs off on that schedule, now they get access to the subplan, and because you have agreement, the temporary layoff is not, by definition, a constructive dismissal. Work share agreements is another tool a lot of employers have used multiple times. For those who are unfamiliar with it, this is where two employees at least, that's the minimum, will share one position, and EI pays them on their non-working days, subject to EI eligibility and limits. Now, what's interesting about this, for those who aren't aware, is that although they have agreed, the government almost instantly enacted a doubling of the period, 38 weeks to 76 weeks, they did not make this easier. And I don't know why, but there are a number of rules that, quite frankly, are not productive and not conducive to giving the employers the flexibility that they need. My hope is that they'll relax these rules in the coming days, but for now, we still have sort of ceteris paribus, as they say. All things being equal, we have to assume these rules aren't going to change yet. And so what you do is you create an umbrella work share plan, which gets filed with the government. That plan has to include that, here are the details of the layoffs we're going to have. Here are some general statements about the recovery plan. And obviously your recovery plan at this point is to hold your breath and pray. But feel free to say that as the economy improves, we will look to return people from temporary layoffs on a staged basis in a certain order. Be truthful, but you don't have to have all the answers right now, to be clear. But one of the issues that I find, and I'm working with a lot of clients on this, is the work share agreement still requires, under the umbrella of the plan, that you create work share groups. And so these are work groups of people under the work share plan who are going to share as a group based on the classifications and duties that they perform. They're going to be sharing the available hours in their work share group. And the rule is everyone shares equally. And so what happens is, let's say you have 10 employees who very clearly fit the description, and there's really no practical, reasonable way to divide somebody out of that group. This is the group that this is 10 people strong, and we're going to divide them and have a work share program. If everybody agrees, fantastic. If you have one or two holdouts, you have a problem. And the problem is that you can't implement a work share agreement with two people working full-time hours who would fit under that umbrella of the plan group, and neither can you have those two people off on a temporary layoff while the other people are in a sense on temporary layoffs and working at the same time. And the theory, when we weren't in pandemic times, is that that's not fair, right? So you have a group of employees who are getting all of the EI benefits and taking an entire break from working, while the other folks are working hard and sharing to try to keep the business running while only taking the minimum necessary from EI. The problem, of course, is in these times, it's very difficult to get everyone to agree. And so my concern is if we don't relax some of the rules on how scheduling works, on how sharing works, on how these work groups work, you may end up in a situation where you have to give people an ultimatum. Agree to the work share, or we're going to have no choice but not to temporarily lay you off, because we can't do that, but to actually terminate your employment if we believe we have no choice but to implement a work share program for your working group. And this is something that my hope is employment insurance will be providing further guidance and hopefully relaxing some of these rules, because if the PM's comments this morning hold true, the government is trying to do things, as they say, to help employers not lay people off and not terminate employment. So relaxing these rules, I think, is an important first step. When you go to the COVID-19 page on Service Canada's website, they're expressly saying this is one of the tools that they want employers to access, and in my humble opinion, they need to make that easier. But again, last point, if you have agreement, not a constructive dismissal. And the other thing is, it's not even considered a layoff because these employees can be on a work share program for up to 76 weeks, and the maximum reduction is 60%. And so while ordinarily that might be considered a layoff, instead this is a work sharing agreement. So it's effectively a modification to the terms and conditions of employment. So it doesn't trigger the 13 weeks and 20 while they're on this plan, and it is not a constructive dismissal because you have agreement. Now we have a bunch of bullet points here on preparing your business continuity plan. We're going to go into these in a much more quick fashion because we want to get to the questions and then use the last half hour for that. So business continuity plans, obviously, if you haven't developed one yet, then let's rickshaw one together with a bunch of pieces and use some duct tape and chewing gum here. But ultimately, we need to make sure that if we are going to have policy statements and policy changes to existing or new policies, we need to communicate those to the employees affected by them, remembering that you can't require employees to comply with something that you didn't give them fair warning of. And also, if you need people to be acting in a consistent fashion, you need to ensure that everybody has a copy of the new plan. You want to look at access for remote work options. Everybody, by the time we got to this webinar, is already looking at that, and I'm sure you've already made some plans. But keep in mind that if you're one of those businesses where you have people who don't have to remote work, but who in fact are allowed to be open and can perform their work under these circumstances from the office, you, from a health and safety perspective, should still be looking, in my view, and I welcome Ryan's comments later on this, but I think you have an obligation to take all steps reasonable in the circumstances to protect your workers. And so I think even if you have the right to operate, you have the right to have people go in to do their work. If it's possible for them to remote work, then I think you have a duty under the Health and Safety Act and just generally to take those steps. From a security perspective, we're going to want to take very special steps here. And I am not an IT specialist by any stretch, although I work closely with our IT folks and our insurer to ensure that we have all the protection we need and that we have security measures in place to prevent, especially with all this remote working, unintentional, most likely these things are human error, unintentional breaches of our security policy. So be very careful about that, and also be careful about an issue that used to occur and which was not really an issue so much as it is now, which is technically speaking, somebody checking their email, doing work while they are not on the clock may be work. And if it's work and you suffer it to be done, then that may lead to overtime claims. And no one's really talking about that right now, but just be aware that if you have employees who are remote working, you should be telling them if they are eligible for overtime and those sorts of things under the Employment Standards Act, you should be telling them what their hours of work are. And you should be insisting that unless you phone them on their cell phone and tell them you have an emergency, that they not be doing any of that work. You also want to take, and obviously we can't do this in advance, but we need to launch into triage now. What are the essential aspects of our business? What are the essential supply chains, employee work groups, and those sorts of things? And we may need to make these decisions on the fly. So I won't go into them in any detail, but that seems readily apparent, I think, at this point. And I think we also need to, from a health and safety perspective, to Ryan's comments, we need to assess now as part of our obligation to take all precautions reasonable in the circumstances, whether there are workers who are at risk as a result of the work that we're giving them and the places where we're requiring them to do that work, and what steps can we take to ensure their health and safety. And I think that you need to take those steps now if you haven't done so already, and you need to do so on a formal, a documented manner. So if somebody does contract COVID-19 and something serious happens and later on they bring a workers' compensation claim, they're going to get benefits anyways if it was in and of the course of employment. But what if they put someone else at risk? What if they put someone else at risk who is not an employee and covered by workers' comp, where there could be transfer of costs and things like that? You may have liability for things like that. And so I think you want to take a close look at what you have people doing, what protections you're put in place, and to the extent possible, ensure social distancing and wherever possible, remote working. And of course, ensuring communication lines remain open during the crisis. So this is just here's the who's who of the Where's Waldo guide to how to create a pandemic plan. We were going to go into this in a much more detail, but I think at this point we're going to get to your questions, and then we'll take it from there. So. let's just pull up the Q&A. And for those of you who may have to leave because this was originally going to be a 1-hour webinar, we're going to be taking sort of the highlights from the Q&A, and we're going to prepare an update for our site as well. So we've got a number of questions here. Ryan, I don't know if you can see them.
I can't, Jeremy, so you're going to have to read them out.
You can't. Okay, so I will hand out the questions as I think it makes sense. So obviously we've got a whole bunch of folks wondering why the slides aren't up, so apologies for that. And then we have a question. So this one I think is for Ryan. Let me just pull this one up. How do you compel an employee to work in an essential business if they choose to self-isolate? Ryan?
Well, I mean, we are running into a world of hurt here, so we have to be kind of careful. So if we're talking about I'm assuming for a moment that we're talking about a business where the right to work refuse doesn't exist. If someone chooses to self-isolate, and I'm assuming that there's, for a moment, that they're not articulating a specific basis to do so, i.e. they traveled, they came into contact, all that sort of thing. At that particular point, that person exposes themselves to disciplinary action. We know that from the decision of the Labor Relations Board in Hamilton Wentworth Jail and many other cases. So for those of you in the essential service, I had one client that was dealing with a highly essential service where people were saying in the absence of any legitimate grounds whatsoever, they weren't going to do their work, and ours was, well, you don't do your work, you're fired. So, I mean, again, you would want to be very careful and never proceed without legal advice on something like that, but that is kind of the general approach. If the work refusal applies, it's a different story. If someone is just saying, I'm not coming in, and because of my general fears of COVID-19, then that becomes a work refusal that will have to be addressed by the Ministry of Labor, which again, I mean, your investigation is, we've taken all the appropriate precautions, there's no reason for this person to refuse. You then engage the Ministry of Labor and engage the work refusal process in the manner contemplated by the slide we set out earlier.
Okay, so one point, I was just writing down some notes as Ryan was speaking earlier in the presentation. I didn't have a slide to specifically discuss this, but I wanted to mention the Labor Relations Board and Human Rights Tribunal of Ontario have both announced as tribunals which are captured by the government orders suspending hearings and deadlines that they're taking certain actions. The Human Rights Tribunal is maintaining all general deadlines. They're canceling all in-person hearings, and they are rescheduling everything else. They have already started sending out notices to our firm regarding Human Rights Tribunal applications that were scheduled for in-person hearings, and they're already scheduling these for remote hearings, or at least taking submissions from the parties. The Labor Relations Board similarly is accepting applications. They're processing them. They have determined that the suspension does not apply to them for all things. And instead they're instituting new policies. And so if you get an application for certification or a construction grievance, if you're already unionized, then you can expect that those processes will unfold as usual. The case management matters will happen remotely, and the board has already released a decision where an employer party in an application said, we're okay having an electronic hearing without dealing with the preliminary issues and evidential issues, but we're not okay having this go on the merits, like dealing with the actual substance of an application. And the board basically said 10 years ago, when Skype was in its infancy, okay, now the board knows what it's doing. We're not going to delay applications for the foreseeable future. We're going to be compelling parties to have e-discovery, essentially, and e-hearings immediately. And so you can expect if you get these applications, they will be processed normally and the deadlines will be fast and furious, and you will be required, subject to exceptional circumstances, to have a hearing electronically using Skype or Zoom or something like that. Okay, let's just scroll down to see what other questions we've got. Okay, a lot of
Jeremy,
people thanking us for getting
how to ask the question. Jeremy, you might want to go over again how to ask the question, because I guess that might not have hit the screen.
Oh, sure. So we do have a lot of questions here, but in case you haven't figured it out, let me go back to the first slide, I suppose. Sorry if that makes somebody dizzy. What you'll see here is that there is a button you can click to if your question window is there. Type in your question, hit send. If you can't see that button, you want to hit the little minus. So there'll be a plus, which when you click will turn into a minus, and then you can enter your question and hit send. If you don't even see that, hit the orange arrow. That'll expand the control window, and then you'll be able to put that in. And now I have lost my question window. Okay, here we go. Right. Okay, so now we have a few more questions here. So let me go to the next one in order. When you say we can ask an employee to stay home if they are symptomatic, does this mean they have symptoms at all? I.e., can we force an employee who has a cold, who has just sort of cold symptoms, to stay home? Ryan?
Well, sure. I mean, I think ultimately we have to walk into that self-diagnosis on this on this disease is reasonable. And I think that when you're having someone with a cold, remembering that virtually almost any cold symptom, most of them anyway, are based upon publicly discussed potential symptoms of COVID-19. I don't think that you mess with this sort of thing. No one's going to. You're taking all reasonable precautions, and I think that, yes, cold symptoms, you can take those steps.
Okay. We've had a comment, and it may be simply because all the circuits are overloaded with all the online webinar platforms, that Ryan and I should speak a little more slowly so that the words come out clearly through the audio. Apparently is not as clear as usual. So sorry about that. Hopefully you've been able to follow, and we'll do that during the Q&A. Another question we have here, is it the responsibility of an employee who's working remotely to advise their employer they have sought or been tested positive for COVID-19, or will public health contact the employer? So first of all workers have a duty under the responsibility code to advise if there's a risk. If that employee is working from home and contracted it while working at home, then ordinarily I don't think you would assume that that was contracted in and of the course of employment. Ryan, what do you think? Sort of a
no, I agree with you. Jeremy, I agree with you on that. I don't think that there would be any necessarily any obligation to notify the employer if they're not coming into work in any way, shape, or form. If they're strictly like an at-home contractor, I mean, except of course to the extent that they're unable to work, in which case, in which case it doesn't really impact the safety of the workplace, and you're not going to be notified by the province. That's not going to happen.
No, that's certainly not going to happen. But to your point, I mean, if they notify you that that's the reason why they can't work from home right now, even though they are at home, then that'll engage your leave policy. I mean, it may mean that instead of working from home, they're now under a declared emergency leave, or it may mean that they're subject to your sick leave policy, depending on how it's drafted in the circumstances. Just scrolling down for some other questions. Do you expect that the 13-week layoff period will be extended? Well, that's an interesting question. As it stands, I believe the answer is no. The province has been looking for ways to put money in people's pockets. I actually am surprised that this isn't something that has been discussed more, and I've mused about this with my colleagues, but theoretically, the only difference between an employee with a collective agreement that gives them recall rights up to 35 weeks and an employee who doesn't have a collective agreement and isn't represented by the union is that their contract is an individual contract, not a collective agreement. But it's still a contractual agreement where the parties have agreed through their legal representatives, either themselves or their union, that a 35-week with recall rights is permissible. And if that's all that's required, why wouldn't we extend that so that employees working for employers forced through no malice at all to lay people off, to help everybody avoid triggering a statutory termination at 13 weeks. It's a fantastic idea. I think they should have done it years ago. I don't really understand why they never have, and hopefully maybe someone will look at it today, but I have heard no rumblings that anyone is talking about doing that. So someone asked another question about the subsidy for small business of up to 75% of wages. I made a comment on that at the very beginning. My understanding is it's not 75% of wages, but it's taking the wage subsidy, which was accomplished by taking 10% of the remittances that employers deduct and then have to remit to the federal government. You take 10% of those remittances and just keep them, and that's the way the government is giving you the subsidy. My understanding of the announcement from this morning is that you'll now be able to, instead of holding on to just 10% of the remittances, hold on to 75% of the remittances. I have not heard that this is a wage subsidy where they're actually going to be allowing you to, they're going to be giving you money to pay wages over and above that. It's a percentage of the remittances, to my understanding.
Yeah, so there's a cap on that amount as well, right? It's not.
Well, there was, and so I would assume that they're going to extend that cap now that they've increased the amount. Whether they do so proportionately or not, we'll have to wait and see. They haven't announced all the details. So another question, and perhaps this is a good one for Ryan. If 95% of our workforce is now working remotely, well, congratulations to that employer who's able to do that. What obligation do we have under the Health and Safety Act to conduct workplace inspections? It's an excellent question.
You certainly raise an outstanding question. Certainly, the only guidance I can give you on that is a very recent decision of the Supreme Court of Canada, which was interpreting the Canada Labour Code with respect to what was reasonable for the Canada Post to inspect for its workplace. The union had taken the position that Canada Post and the committee had an obligation to inspect every road in Canada, which, in light of they're the second largest country in the world, would have been a somewhat daunting task, to say the least. And the court basically, interpreted that particular provision of the Canada Labour Code as saying, it, the majority of the court anyway, as saying that the way it was written is you don't have to do that. That's not a reasonable interpretation. Because the workplace, obviously the roads are not under all of the roads in Canada are not under the control of Canada Post. Following that analysis, one would hope that the answer is that you don't have a specific obligation to inspect people's workplaces. As a matter of due diligence, you might certainly want to send out a notice dealing with the kind of health and safety issues that could arise at a home office, but I would probably have that issue as being fairly low on the list of concerns I would have at the moment.
Good point. Hopefully we don't see any reprisal claims or other things related to the failure to inspect someone's home office, which they have total control over. So now we have a question here. As a long-term care home employer, we would like to limit the employees to work at only one long-term care home as an infection control measure. Employees have the option of choosing which employer they choose, or I guess which location they choose to work for. For employees who choose to work at their other employer, we are placing them on an unpaid leave of absence. Are we at risk of being deemed to have temporarily laid them off? Well, I mean, first of all, if you have people working at a long-term care home, you may be unionized. That's not the case in all cases, but I would say a significant number of unionized long-term care facilities are. So you're going to want to have a close look at your collective agreements. Many long-term care homes will have a collective agreement that applies to each home, like if they have multiple homes as part of a group of homes, and others will have one collective agreement that applies to many. And so if you don't necessarily have the right to treat these separate facilities as separate under your collective agreement, then you may be risking a violation of your collective agreement by restricting those things. So just lay that out there. But on the assumption, because that's specific to specific collective agreements, on the assumption we're not talking about a unionized long-term care facility, this is a bit of a dicey issue. And the reason is that a unilateral change by the employer to put people into a home that they normally would not be working in, even just that decision on its own may be a constructive dismissal. That said, I don't think it's one that many people are going to take issue with. If instead you try to put people on an unpaid leave of absence I'm not sure what your basis is for putting them on an unpaid leave of absence. It sounds to me like what you're saying to them is, we have 3 facilities. We have work for you at facility 1. We don't have work for you at facility 2 or 3. If you accept an assignment to facility 1, then that's great. If you don't, then we're laying you off. I really don't see how this is a leave of absence. This wasn't requested by the employee. It's not actually required by any government directive, to my knowledge. What this is a straightforward layoff because you have a lack of work. And if you institute a temporary layoff, then if you have the right to do so with these staff, like it's something you've done in the past, even if you don't have an express right in your contract, then maybe you don't face a constructive dismissal risk, or at least you have a defense. On the other hand, if you implement it, then there might be an issue there. I will also point out that it would be a constructive dismissal. I also point out that depending on the nature of the work these people are doing and whether they are professional staff, there may be regulations that apply specifically to them, and whether or not you're allowed to schedule them, reassign them, require them to return from leave, and so forth. And so, again, that's a very specific question to your organization, but in general, is it possible that there's a regulation or professional rule that requires them in these circumstances to accept those assignments? Yes. Will there be a professional rule or regulation that allows you to put them on a leave of absence? I'm not aware of any. Would it likely be a constructive dismissal otherwise? Potentially. So hopefully that wasn't too long an answer, but a lot of aspects to that question. Next question, can you provide more clarity on who is eligible for loss of earnings under WSIB if they are doing or have become injured and need to be doing modified work, not specifically related to COVID-19? Ryan?
Okay, I mean, I guess that actually with respect to workers' comp in general, it's a fairly simple situation. If someone is off right now for LOE benefits, they keep getting them. For people that are shut down as part of a COVID-19 shutdown, whether it's by government order or otherwise, in general, they are not going to get WSIB benefits. The one exception, the WSIB has not published this as guidance specifically related to COVID-19, but board policy on temporary cessation of earnings states that if someone is laid off only because of they're losing their modified duties and only laid off really because of their injury and they wouldn't otherwise be laid off, but the injury is causing the layoff, then they likely will have entitlement to benefits. So that's that's going to be a fairly narrow group of people in these circumstances, but certainly it's as a matter of due diligence, it's probably not a bad idea to communicate to people being laid off that are on workers' comp that they're being laid off, assuming this is true, of course, that they're being laid off as part of a general layoff and they were going to be laid off whether they were subject to a claim or not.
Okay, so one clarification on that last question that I answered. If it wasn't a typo and it was really meant that it's more than one employer, it really is the same answer. But if the question is, you're working for 2 different long-term care homes, and at our home, we want you to either work at your other employer or work for us, but not both. You can't force them to quit their other job. All you could do is say, well, if you voluntarily resign your work over there, then we won't lay you off here, I suppose. I don't believe that would be a reprisal under any statute, subject to other concerns. But in any event, if you actually have to say, well, if you're going to still work there, you can't work here, that's a layoff. That's not a leave. So another question here, will the social distancing become enforced by the Ministry of Labor in workplaces? Ryan?
You have asked the million-dollar question. There has been nothing but confusion on that question. And in part, the obvious example I'm going to give you is construction. Construction takes place outside, sometimes, but not always. And in much construction work, it is incredibly difficult, in some cases impossible, to maintain social distancing. The Occupational Health and Safety Act says one should take all precautions reasonable in the circumstances. So one could imagine an argument that says that social distancing is a necessary and reasonable precaution in light of it being recommended by the government. The other side of that coin is, though, that construction, amongst other things, has been declared essential. So does that give some more latitude to it, that the province should be deemed to have contemplated that some of these essential industries, many of them that are on that list, social distancing is impossible, especially those that are already subject to the work refusal exemption. So the answer to that question is possibly, but who knows? In the short run, that's just something that you're going to have to determine on a workplace-specific basis. But what the actual answer to that question is there's quite frankly no certainty on it.
Okay. So that's the $1 million question, and hopefully no one gets hit with the $1 million prosecution there, Ryan. I wouldn't want to be the first one at the Labor Board standing in the dock for that case. So another question.
No, I wouldn't. I probably will be, but I wouldn't either.
I guess we should say you will be there, standing next to the employer, most likely. But we'll wait and see. Hopefully that doesn't happen. We are considering. Here's another question. Considering laying off 3 employees, one of whom is pregnant and due in June. Will being laid off now affect her ability to collect maternity parental leave? So well, I guess we'll put it this way. First of all, this employee is still there, so they're not on a leave, and you're not initiating layoffs with other people that will affect them when they come back, which is another question. What we're dealing with is a selection for layoff. So my advice to you is select people for layoff based on the normal criteria that you would use to select them for layoff. If you're selecting them for layoff for purely business reasons related to downturn, lack of work, those sorts of things, and it's not in any way related to her being selected because she was about to go off on leave anyways, so it's not that you have 10 employees and she was one of the 3 selected because you thought, well, she's going to be going off on leave, so we may as well just put her on the list of people that we're putting on layoff. As long as that's not the case, then what you're doing is a lawful layoff, provided you have the right to lay that person off, which is the question we discussed earlier. Will that affect her ability to collect parental and maternity benefits under EI? Well, the question has yet to be answered. So I believe what's going to happen, although they have not said so yet, is that when you have one kind of leave and then you have to go off on a leave that relates to COVID, either because of a layoff or a quarantine or whatever it is, that the EI rules about being able to qualify may be relaxed. They haven't announced that that's going to happen yet. And so I think arguably an employee in her circumstance who following the end of her pregnancy or parental leave or at some point during it caps out her benefits and is no longer able to stay off on the planned leave, she may, subject to the announcement, be eligible for the new kind of leave that applies for employees who don't qualify because they've exhausted their EI accrual for the insurable hours that they've worked before commencing a leave. And the other thing is that the government has already done and will, I believe, at some point soon probably be announcing additional reductions in the insurable hour requirements. I'm hoping that that's going to be coming, but they have already, for certain types of agreements, been reducing the amount of time that you have to wait between work share agreements or subplan renewals and things like that. So I think that we very well might see somebody realize that the benefits that we're trying to get into people's hands will only be there if we relax those requirements, like for the requirements in work share that I mentioned before. But as it stands, my advice to employers is don't give employees advice on whether they will be eligible for EI or anything else. Process layoffs, process leaves as you would do in accordance with the law, and be honest when you put out an ROE, and then let Service Canada determine eligibility. All right, another question here. This one I think would be for Ryan. Although we understand that employers are not required to provide additional PPE, so personal protective equipment, if not required in their jobs, what is the employer's responsibility if they want additional PPE during this time?
Well, I mean, the answer to that question is, I'm assuming you're saying the employees want additional PPE. Your obligation is to provide any PPE specifically required by law and any other PPE required by the employer's procedures, required by a manual for a piece of equipment. and anything else that would be reasonable in the circumstances. Just to give the sort of example, I mean, we've heard a lot about masks, and we know, of course, there's a shortage of those for frontline workers. We also know that the science tells us, from the head of NIOSH and others, apparently, that the mask is not particularly useful to people who are, just to prevent the spread or whatever, in terms of the basic entitlements. So the bottom line is, you have to assess whether the request is reasonable. If there's no basis for it to be reasonable, then you probably don't have to do it. But the thing is with health and safety, and this gets tricky with the general duty clause, I'm just going to be blunt with you. There are times when the answer to that question is whatever the judge or the labor board says it is. But what I think in these circumstances is we just have to use common sense. And employees that are in a non-medical situation, in an ordinary situation, working outside, for example, asking for masks, that's probably not reasonable if Judge Conlon were adjudicating it on today's facts. But I'm not Judge Conlon, so ultimately you have to follow a little bit of common sense. And I think that the answer is looking at publicly available, reputable information, like you want to rely on things that are from the medical officer of health, not something you see on Reddit.
Okay. So we've got a question here, which, I'm going to answer it, but the individual may not like it. And when that's done, they might want to reach out to me afterward for some guidance. My employees are presently off and getting full pay until April the 6th. I did not make any promises after that date. Can I offer them 60% pay moving forward or taking an ROE? These are all permanent part-time staff. So first of all, they're off with full pay. So unlikely a constructive dismissal, although in theory, in normal times, it could have been. Here, I don't know if you're putting them off with full pay and they're working, or they're off with full pay and you've effectively enforced vacations, which may or may not be permissible depending on your contract. But can I offer them 60% pay moving forward or an ROE? Like that you don't offer someone an ROE. Let's just be clear. An ROE is something you're required to issue if an employee receives has an interruption in earnings, which is defined as any 5-day period during which they earn less than 60% of their regular pay. As soon as you hit 59%, you have a duty to issue that ROE, and they have a right to apply for EI, and you're not involved in that process anymore. If you want people to go off on an arrangement where they're working for only 60% of their pay, the only way to do that with agreement that I think is likely to succeed and still give them access to EI would be to put them on a work sharing agreement, if you can, with other folks. Alternatively, implement a sub-plan with a top-up where you agree to pay them and you can, in those circumstances, give them a little bit of work even while they're off on the temporary layoff with your sub-plan, provided that the combination doesn't exceed the calculations under EI. So I guess the short answer is you can do whatever you want, I suppose, but I don't see how offering someone 60% pay is going to be agreeable to them unless it's subject to a work share agreement, or you're actually just going to implement a temporary layoff because they're not working anyways, and you implement a registered sub-plan which tops them up on top of their EI at a far lower cost to you. And again, those are plans we've been putting in quite a bit. So we're going to extend the time for our chat by an additional 10 minutes, just because we do have, again, still a flurry of questions, a lot of people on this program, but we will go through the ones that we missed and see if we can add some of the highlights with answers to an FAQ that goes out. So if we don't get to you, don't worry. Another question we have here, Ryan, for you. For all non-essential businesses, this is the question. I understand we have to be closed to the public, but are there any types of activities that we can still carry out without violating the government's orders? What if the activities involve close contact between employees and they accept the risk of that? What are your thoughts?
All right. Look, this is one of those things that any lawyer with decades of experience will call a legal minefield. you may be right. There may be some possibility that there's some things you could do. For example, I mean, you're running a lawn cutting business. Lawn cutting is not essential, but you can maybe it's possible but ultimately, my concern is that because of the huge potential fines, unless you're the owner of the business, I think employing anybody is a significant risk. Unless you're dealing with something that's like an emergency that the place is going to burn down. So, bottom line, if you have a very specific fact pattern on this, I'd be happy to discuss it with you in detail. But in general, if you're a non-essential business, you are closed. Period.
Yeah, I mean, obviously, that list of essential services, they've carved out exceptions for certain people, like people processing payroll, who should be working remotely anyways in this day and age, I assume. But and also for building security and maintenance. And as Ryan said, I mean, I guess if you're the owner of the business and you have to go check that your pipes aren't leaking and there's no fire, okay, but you shouldn't be operating. I think that's a pretty good advice. I mean, Ryan, it's $10 million is the fine, is it not, for a business that operates in violation of the order?
Yeah, I believe so. It's a very significant number. You do not want to be in court in that situation, especially. I think a court's going to take a very dim view because given how broad that list is, if the province has declared you non-essential, you truly are non-essential in the view of the Crown.
Yeah. Okay. Okay. So, can the employer force salaried employees to use their vacation time rather than continue to pay wages during a plant shutdown due to COVID-19? So first of all, salaried employees, I assume, is a way of saying, number one, non-union employees. Obviously, if a union collective agreement applies, whether they're salary or hourly doesn't matter, although most unionized employees are not on salary. But if you have salaried employees and you have a plant shutdown, and it's not a plant shutdown that you've been directed to shut down, so you are considered an essential service and you can operate, you just don't have enough work, and so you've chosen to shut down, then employees that you send home would generally be on a layoff. And a way of avoiding a layoff, or delaying it at least, is to put people on vacation. Generally speaking, the employer has the implied right to schedule people to take vacation, and to approve or cancel scheduled vacations that employees may already have scheduled. That said, it depends, as the adage goes. If you have a contract or a policy by which you've given up or taken away your own right to do that, so some policies will say all vacations are based on employee requests subject to employer approval, then you may have expressly in your own policy, and perhaps inadvertently and unfortunately, taken away your right to do it. Now, that said, if I'm an employer and I'm trying to avoid temporary layoffs, and I have a contract or policy that says I'm not allowed to put people on vacation and pay them, I might just ignore that policy and roll the dice, because I'm trying to avoid the larger claim of constructive dismissal based on putting someone who I may not be allowed to put on a temporary layoff on a temporary layoff. So if I'm between that rock and a slightly hard place, I'm going to put those employees off on a layoff. I'm on a temporary vacation. I'm going to pay them their accrued vacation pay, and then I'm going to wait and see if one of them has the gall to file a claim alleging that by putting someone on a vacation without their request, that somehow that's a constructive dismissal. And I would have to say, in these times, good luck with that. But I don't imagine a lot of salaried folks have an awful lot of vacation time accrued right now. And so you can't just put someone off on vacation indefinitely. They're going to exhaust that bank and, their overtime bank, if they've got banked overtime hours for salary people, they're going to exhaust those reserves. Number two, those reserves are still cash, right? Like, you're still in a time when cash is light, you're using your cash instead of paying salary to pay out a bank. And there are good reasons to do that, because some of those entitlements will be owing should the worst of all possible fates occur and your business go under. Then, of course, directors are liable for wages and vacation pay personally. So that's something to consider. But in general, this is not a long-term solution. It may present some minor risk, but if you have no choice, then even if your policy says you can't, I might consider doing it anyways, recognizing that that may be a contractual breach. You may expose yourself to a risk, but it might be a risk that you have no choice but to take as a way of mitigating the damage and the impact on your employees. Where are we here? Ryan, within a municipality, can staff be redeployed to a different department that would be considered higher risk to the pandemic, such as municipal-run long-term care facilities?
You are entering into a question. I'm afraid whoever is asking that's going to have to contact us directly. And the reason that I say that is, first of all, the public sector is heavily unionized, and there's all kinds of occupational health and safety, collective agreement issues that arise, and also employment law issues, frankly, that they're non-union, that arise with respect to that. So the answer to that is, I think you'll have to give us a call for a more detailed opinion. That's not a simple answer.
Okay, fair enough. Fine. Maybe I'll give you this one then. That one was too easy for you. You just said, I don't know, give me a call. So I'm going to give you another question. If an employee tests positive for COVID-19 and the employer informs employees who were in close contact, is the employer obligated to inform all other employees?
Well,
I think that goes back to the JHSC, right?
Yeah, it goes back into notifying the Health and Safety Committee. It also comes into doing what's reasonable in the circumstances. I think the people you notify are people that would have come into contact with that person, aside from any notification obligations that go beyond that.
Fair point. And of course, if you notify your JHSC, your Joint Health and Safety Committee, those notifications are not privileged. And so it's entirely possible that employees will learn.
Yeah, and lastly, of course, if the last point that I make is, of course, that if this was a work-related contraction, you would report it to both the WSIB and the Ministry of Labor.
Of course. So someone's asking if we can go over again, and sorry, I just have to pop this up, the steps if we wish to reduce salaries to avoid constructive dismissal. So the only way to reduce someone's salary outside of a work share program without inducing a constructive dismissal would be either A, to reduce their compensation by such a small amount that it doesn't really help you anyways, but isn't a constructive dismissal, or to do so with an agreement. And that's why a work share, which is an agreement, allows you to do that. If you were to reduce someone's compensation without an agreement that you do so, then that will likely be, if it's a significant one, 10% or more, almost certainly a constructive dismissal. There's no way to just unilaterally do that and not suffer the potential risk. Now, again, an employee who has, let's say you implement a 10% wage cut across the board, you don't ask for agreement. The employees at that point will have a choice, however unfair that choice is. Do I continue to work and earn 90% of my pay, or do I quit right there and then and sue for constructive dismissal? And if they sue for constructive dismissal and they claim constructive dismissal, what we do is, of course, we send them a letter which says, we're very sorry that you haven't agreed to the 10% reduction. This was necessary and not personal. And we're notifying you that your job remains available. And we ask that you consider returning to avoid the 90% loss instead of just suffering the 10% loss. And at that point, what you've done is crystallized an opportunity for them to mitigate their damages. And if they fail to take it, then other than employment standards entitlements, which are not subject to mitigation, and other than the theoretically 10% that you've taken away without their consent, they may be exposed to all of that wage loss being deducted from any common law award they would get if they continue on and sue you. So unless it's an employee who has very long service or who has a companion human rights complaint, which would be ways to motivate them to do this without looking at the common law top-up that they're losing by failing to mitigate, I think most employees, when faced with only a 10% reduction, might just grumble and take it. And it's a terrible thing to say, but in these times, people might just be happy to have a job. Now, that doesn't mean that they all are going to accept it. And if they were to tell you they don't accept it, well then, but they're going to continue to work to mitigate, then they're basically telling you right there and then that they're going to work, they're going to mitigate, they're not going to accept your changes, and that way, as a result, when sort of the dust settles, they will have a constructive dismissal claim that they can levy against you to get their employment standards minimums, likely the 10% you've taken away for the period that they continued to work. That would be subject to any common law or contractual entitlement. So if you need
Jeremy,
specific advice on that, give us a call for sure.
Yeah, Jeremy, there's one other point I wanted to make about that is that, first of all, I mean, to enter into an agreement like that probably requires some kind of consideration on top of the wage reduction. Consideration meaning a contract that doesn't give someone something, like just saying, oh, well, you're reducing my agreement, like make an agreement enforceable. You need to provide someone with something, whether it's a cash payment or whatever. I would be very, very, very cautious about trying to amateur lawyer a situation like that. It is incredibly complicated. It's very dependent on your specific workplace in the non-union context. So I think that anyone who's even attempting to do something like that, if that's the direction you want to head, you need to get some competent legal advice, or you could find yourself up really with a rather large bill in court for sure if things didn't go the right way.
Okay. So we're right about at the time we agreed to stop, even with the extension to the extension. So there are an awful lot of additional questions here, and I'm sorry we didn't have time to go through all of them, but we do have them. They're in the system. And again, we are going to take some time to prepare an update with the highlights of these questions. We promise we won't put your name on it, but there are a lot of good questions here that we just didn't have time to get to. So thanks again to everyone. Obviously, our thoughts are with every employee, their families, and every business that is fighting to stay above water at this point. And we're here for all of our clients. And so if any questions arise out of this that do require some targeted advice, if you have specific questions or you have specific initiatives that we can assist with, that's what we're here for. And please do give us a call. Obviously, in these times, you can imagine work is quite hectic. So we're not opening up the phone lines to a smattering of calls. What we're asking is that if you do believe that you need to retain counsel, feel free to reach out to us, and we will get up to speed quickly and hit the ground running. Okay. So thanks very much, everybody. Again, have a great day. Stay safe, and we'll speak to you soon. Take care.